Hi everyone. In this third and final video, I want to cover two areas. First, I want to cover the circumstances in which you will want to retain external counsel to protect the interests of your director, officer, or key employee in a criminal investigation or regulatory prosecution. And second, I want to cover the areas and the documents and the information that you will want to review to assess your company's exposure to criminal liability and also that of your key employee. I get it. It's not easy. As counsel, your first duty is to your corporation, to your employer. But your direct supervisor is someone who may need to be referred out for external help because the interests, as I'm going to discuss in this video, are not necessarily aligned. The CEO, CFO, senior vice president, someone of a significant authority within the company might be the person giving you instructions. But you need to remember that your first loyalty is to the corporation, not to that individual. And that will become difficult because, as I'm going to cover in this video, that individual may have different interests than that of the corporation. As I discussed in our first video, directors, officers, agents, and key employees have different interests from that of the corporation. They are separate parties. Under the various secondary liability provisions we explored in the first video, we know that it is possible for a person to be charged and the corporation not to be charged. And vice versa, it's possible for a corporation to be charged, but the person not to be charged. And in parallel and distinctly, it is impossible for a director to be found guilty of an offense and the corporation to be found innocent. And it is necessary for the corporation to be guilty of an offense for that director to be found guilty. This sets up a very distinct possibility of a conflict of interest. Except in the very specific and narrow circumstance of the owner-operated corporation. And by owner-operated, I mean tightly owned, where it's like a single shareholder who is also the director, officer, and key employee of the corporation. Unless you're dealing with that kind of circumstance, there's an inherent conflict of interest in any criminal prosecution and secondary liability provisions between the director, officer, and key employee and the corporation. The director, employee, or officer always has an incentive to point to the corporation and say, the structures didn't work, the reporting systems didn't work, I gave orders, but my subordinate didn't follow my instructions, or the corporation didn't implement the kinds of systems that I wanted the corporation to implement. Conversely, the corporation always has the incentive to point to an employee, director, or officer and say, he or she gave those instructions, or he or she was acting outside the scope of employment, and the liability of that person shouldn't be attributed to us. Again, there's an inherent conflict of interest between those two interests. So as I discussed in my second video, as soon as it becomes apparent that cooperation with the government might be turning into a criminal investigation, the interests diverge. And at that point, you might need to be thinking about referring out the director, officer, or key employee involved in the incident to external counsel. First, it will actually help to have two separate sets of counsel looking at the same problem, two different views, two different interests, two different ways of looking at the same problem, meaning more defenses get brought out into the open. Second, and most importantly for many of you, you will have an ethical duty to refer that person to independent counsel. You have a primary duty to your corporation, but you have a situation where someone within that corporation has very different and potentially diverging interests. That person needs to be referred out. So let's cover the steps that you can take to set up the defenses on behalf of the corporation when you think that a criminal investigation might be underway and to minimize the risk of criminal exposure. Let me first preface all of this by saying nothing that I'm saying right now goes to the substance of an offense. So that will be covered depending on the type of industry that you're in. I'm not here to talk about how to defend yourself against an environmental spill or a securities fraud or an income tax evasion or a workplace incident. What I'm really trying to get at is looking at the corporate function and how do you protect the directors, officers, and key employees within your corporation when those investigations come up. So in light of that caveat, I'll say as soon as you start seeing inspectors starting to tick the boxes that I covered in the second video Are they asking for emails originating from individuals within the corporation? Are they looking at diaries and meeting logs and other forms of communication specific to individuals around a certain incident? Once you start seeing those kinds of things, or perhaps a key employee is being brought in for an interview, you have to know at that point that there is a potential for criminal investigation to have started, and you need to start thinking in those terms. If you believe that that process has started, you should immediately retain independent counsel for the individuals involved and potentially for the corporation as well, with criminal and regulatory defense experience. Engaging a civil litigation lawyer may not be the wisest. Charter rights are very specific, especially the legal rights section between section 7 and 11. Someone understands information is to obtain, production orders, search warrants. These are all aspects of the law that many civil lawyers do not have exposure to. Similarly, a pure criminal lawyer, it may not be as alive to the nuances of how directors, officers, and key employees need to work within a corporation, as well as the unique dynamics and powers of the state when using their inspectional powers. I often think that many criminal lawyers look at the production orders that are available in administrative context and think they're all in breach of their charter, when in fact the courts have said many of them are charter compliant because they further the needs of the regulatory state. So you do need a lawyer who understands both the criminal side and the nuances of working within a business in a regulated industry. I've now covered when you need to worry about a criminal investigation, what needs to be thought of, who needs to be involved. And now I want to talk about how you want to do it. And specifically, I want to cover what are the things that you're looking for to assess your company's criminal exposure and your key employees' criminal exposure for the purposes of assessing secondary liability exposure. So how do you assess the extent to which a key employee, director, or officer might be liable under a secondary liability provision as opposed to the corporation? And the focus is to look at the words themselves in these provisions. Did the person direct, permit, authorize, or acquiesce to the actions that led to the offense? And that lends itself to looking at the chain of communications between that person and others within the corporation and the nature of the chain of command. The more the person is involved with the events that led to the offense, the more it could be said that the person permitted, authorized, or acquiesced to the offense. These types of activities may not just be explicit, i.e. in the form of the communications, emails, memos, letters, or direct orders given verbally to an employee, but it could also be implied means of communication, often through formal chains of command, processes, and procedures. Again, through explicit or implicit directions from a director, officer, or key employee down to subordinates. That is what governs whether someone permitted, authorized, or acquiesced to the corporation's activities. That is what you want to look at in assessing the extent to which this person needs separate representation. Understanding the weight of all of these factors will require you to look at the internal records of the firm. You will want to understand very precisely the director, officers, or key employees' role within the events leading to the offense. And that will require you to activate your data preservation and record preservation procedures, your anti-spoliation processes, and all the other things that you would normally do to investigate events leading to an offense. And there you have it. In the first video, we covered what secondary liability is and why it is a form of exposure for directors, officers, agents, contractors, and key employees of a corporation that is separate from the offenses committed from the corporation. Our second video talked about the danger zone, the times when you're cooperating with your regulator or the state, and how that might move into a criminal investigation that produces evidence in a criminal or regulatory prosecution. In our final video, we covered about steps you can take to best protect your company as well as the key employees within it. It's been a pleasure to work with the Canadian Corporate Counsel Association to produce these microlearning videos for you. At Ascendian Law, our lawyers focus on corporate commercial litigation in highly regulated industries, public law, administrative law, and regulatory defense. We're very pleased to answer any of your questions. Come visit our website. I hope we've given you some useful information. Thanks for watching.